Welcome back, everyone, to True Crime Desk. I'm Richard. And as you can probably tell by the framing and the picture quality, I'm doing something a little different today. I'm using my webcam, and I'm going to go over the Alec Baldwin hearing that they had a few days ago where he's trying to get the case thrown out. So it's about 8 hours long, but I broke it down to about an hour portion. And it's basically going to be going over the firearm part because if you guys don't know already, I'm a gunsmith, so it's kind of in my wheelhouse. So I thought it'd be really interesting to go over it and let you know what I think about it. So with all that being said, let's get into it.
All right, let's go into the full and font motion if we're ready. Are we ready?
We're ready.
We are, Your Honor, and I will be handling that with the court's leave for the defendant.
All right, thank you. All right, so the motion is, get my motions here.
It does take a while to get into this. I did scrub through this a little bit, but I didn't look for the final her ruling, so I wanted the ruling to be a surprise
All right,
to me.
this is the motion, defendant Alec Baldwin's expedited motion for.
You guys might know the ruling already if you've watched this, but like I said, I purposely didn't.
Motion to dismiss the indictment for failure to allege a criminal offense. Okay, thank you. Go ahead.
Thank you, Your Honor. And I haven't appeared before you before. My name is John Bash. I'm one of the attorneys representing Mr. Baldwin, and it's a pleasure to be here. One bit of housekeeping before I begin. I know we have a motion later today that involves witnesses. If you had a sense of when that will be, we can go ahead and start notifying the witnesses to be ready at a certain point in time, if that would be helpful to the court.
I believe after the lunch hour, this is probably going to take us to noon Mountain Time, this motion, or if it doesn't, we'll break at noon. And in other words, I'll call you back at 1, basically.
Okay.
Mountain Time.
Thank you.
All right, let's go.
Thank you, Your Honor. And with that, I'll begin. May it please the court.
Yes.
Please.
We have moved under Rule 5601D to dismiss the indictment for failure to state a crime. And our submission, Your Honor, is pretty simple. Under State versus Henley, which is the New Mexico Supreme Court's authoritative construction of the involuntary manslaughter statute, that's at 2010 NMSC 39. In order to convict a defendant of involuntary manslaughter under New Mexico law, the state must establish the defendant's subjective awareness of a substantial risk that his or her actions could cause harm to another person. It's a subjective standard. It differs in that respect from certain other recklessness offenses under New Mexico law. And our submission, the state, and I think we will show this, has abjured any ability to show that Mr. Baldwin had a subjective awareness of a risk that the firearm in this case was loaded with live ammunition.
Let's see. That's where I'm going to disagree right off. You have a firearm in your hands, as I stated, and I did my other video. And those of you who didn't watch it, I did a video on this earlier. And those of you who don't know, I might have forgot to say, I'm actually a gunsmith. So this kind of is my field of expertise, I guess you could say. And I disagree completely. He had the firearm in his hand, and anytime somebody puts a firearm in your hand, you should automatically assume that it's loaded. So it doesn't matter. All the rest of it's irrelevant, in my opinion. And remember, just keep in mind, this is all my opinion. And this is just what I believe from my years of experience when it comes to firearms. I'm not a lawyer, so the other part I don't know.
Without that essential piece, the state cannot establish the element of the offense. It's not a question, Your Honor, of evidentiary sufficiency. It's not a question of how different fact finders can view the facts. It's a logical, legal question. The state has said that guns kill people. That's true. They kill people when they are loaded with live ammunition. If the state cannot even allege the essential piece that he was subjectively aware of a substantial risk that it was loaded with live ammunitions, they cannot prevail. Now, Your Honor, there has been a dispute between the parties about the extent to which the state is bound by its factual assertions in the Gutierrez-Reed trial, and I'm going to go into that in a little bit. But I don't think the court actually even needs to address that dispute. because the state's concession is on the face of the opposition that it filed to this motion. I direct the court's attention to pages 14 and 15 of that opposition. I think it was filed on May 21st. In response to our argument that they can't prove, and they haven't even alleged, that Mr. Baldwin was subjectively aware of a substantial risk that the gun was loaded with live ammunition, they don't say, yes, we can. And I'll get into this more in a second, but they say two things.
But real quick, they don't need to. He should always assume that it's loaded. So they don't have to prove that it was loaded. I mean, he doesn't, he has to assume that it's loaded. It's his responsibility as a person with it in his hands. Once again, he has to assume it's loaded. They don't have to prove it was loaded. It's his responsibility. It's in his hand. So let's move on.
They say, well, if he had done that, we'd be charging him with second-degree murder. That is a concession that they do not think he did that they cannot allege that, and they cannot prove that. Second, they point to a bunch of other stuff he did. And we'll talk about that, but none of that other stuff poses a danger to another person unless there's live ammunition in the gun. None of it does. They can't prove that element of the offense. They don't even claim to, and it's clear on the face of their opposition brief. So let me talk just briefly, Your Honor.
Like I said, I did scrub through this a little bit, so you're going to see as he goes further. Their definition of ammunition and mine are slightly different, but we'll see when we get there. I'm getting ahead of myself.
About the full and font standard, because I know you're intimately familiar with it, but the parties have joined issue to some degree on what that standard provides, and the state's wrong about this, and I just want to clarify why they're wrong about it. The original full and font case back in 1995, as I'm sure the court knows, said there was a distinction between questions of fact and questions of law, and that a pretrial motion to dismiss under, I think back then it was 5601B, now it's subsection D, was only proper for questions of law. And the state kind of clings to this distinction between questions of law and fact. But critically, Your Honor, in 2016 and 2017, in the Pacheco and Platero cases cited in our brief, that's 2017 NMCA 83 and 2017 NMCA 14.
I'm trying not to interrupt too much, but you know how YouTube is. I have to stop it every now and then, and they'll go on stating case after case, and it can kind of get a little draggy here. So it'll pick up a little bit. So let's get going here.
Court of Appeals rejected the distinction between questions of fact and questions of law. And you can see why. It's in any case where it's a question about the application of law to facts, you can always frame any particular issue as a question of fact or a question of law. So it's an unhelpful distinction. What the Court of Appeals said instead is take the undisputed facts in the case, whether alleged, whether the state stipulates to them, doesn't dispute them. Take those undisputed facts and ask, can the state on those undisputed facts satisfy the elements of the offense? And what the guidance that the Court of Appeals gave in Pacheco was that typically that inquiry will turn on this question. Can the state reasonably assert the availability of additional evidence to satisfy the elements of the offense? So it's no longer, Your Honor, an issue of whether it can be characterized as a question of fact or law. It's a question similar to motions to dismiss in the civil context of whether the undisputed facts show that the state cannot satisfy the elements of the offense. And just to tie the loop on that, the state suggests that mental state questions like recklessness, knowledge, intent can never be the subject of a successful full and font motion. That is incorrect. In the published 2013 decision in Moreta, which we cite in our briefs and is at 2014 NMCA 60, the Court of Appeals did an intensive analysis of the facts alleged by the state to determine whether a full and font motion should be granted on a recklessness issue.
Real quick, see, in my opinion, like I said, I'm sorry, but I have to I've stopped it every. In my opinion, lawyers have a tendency of, they're lawyers, so that's what they do. It really is pretty basic. It's a firearm in your hand, and it's not as complicated as they try to make it seem. But there's a lot of legal stuff they have to go through, but they're not firearm experts. So when it comes to firearms, it's pretty basic. What you should do and not do. Well, that was really said badly, but it's basic what the rules are legally. They try to add a lot of spin to stuff to make it seem more complicated than it is. Well, I can't speak.
Was abuse of a nursing home patient by a doctor. So it is just not true that mental state can never be the subject of a full and font motion. It is true that it rarely is, but you rarely have facts like this where the state doesn't even allege that the crucial link between action and someone getting hurt, that the defendant had subjective awareness of that crucial link. That's pretty rare, and that's why this case is different. So, elements of involuntary manslaughter, and I don't think the state disputes this point. Under Henley, and the Henley case says this twice on page 108 of the Pacific Reporter, the defendant has to have subjective knowledge of the risk, of the substantial and unjustifiable risk that his or her actions will cause harm to someone else. I don't think that's disputed in this case. The state can correct me if I'm wrong. Critically, that's different than the way recklessness works under a lot of other statutes of this state. For example, the child abuse statute, which the Supreme Court just addressed a few months ago in the Taylor decision, has an objective standard. So it's what the defendant should have known. That's not true on involuntary manslaughter. The Supreme Court has been very clear about this. It requires subjective knowledge. What did the defendant actually know about the risk?
Now, Alec Baldwin is a grown man. He knows when you have a firearm in your hand, there's always a risk of somebody being killed. Or, Cade for YouTube. That's what happens. So he's a grown man. He knows better than that. So like I said, this is all this bluster, I guess you'd say. He knows there's a risk because he's an adult. Everybody that's an adult knows anything about firearms, even basic, knows there's a risk. So he's aware of it.
So just putting those two things together,
or he should be.
The full and font standard and the elements of involuntary manslaughter, the state's position cannot work logically. On pages 14 and 15 of their opposition brief, in addition to numerous statements they made on the record in order to secure a conviction of Ms. Gutierrez, their position is that no one could possibly know that there would be live ammunition on this set. They do not intend to argue, if their briefs and filings and statements are to be believed, that Mr. Baldwin had any subjective awareness of a substantial, not just any risk, a substantial risk that that firearm was loaded with live ammunition.
Once again, he should assume that it is. It doesn't. All the rest of it doesn't matter whether there's a substantial risk, whether there ever is or ever isn't, whether it has been in the past and other sets years, and it doesn't matter. He should always assume. Once again, it's the same thing repeating over and over again, and I'm going to have the same argument for everything they bring up. It's just there's no excuse for it. He should always assume that, and go into it. You should assume that there's live ammunition everywhere. Every time you see that stuff, it's live ammunition. You just assume that. It's common sense. And if he doesn't know that, it's ignorance. And ignorance is no excuse. So let's move on.
If not, they can't show that he was aware of a substantial risk that whatever he did, whatever they allege he did, could kill somebody or could harm somebody. Because a gun does not kill people unless it has live ammunition. It just doesn't work. It doesn't make sense logically, and they have no answer to that basic problem. Now, we've given the course.
Let's see, real quick, I'm going to answer that. There's live ammunition. Their definition of live ammunition is a full round where you have the full case with the primer on the bottom, and then you have propellant, and you have the bullet or the projectile on the top. That's what his definition is. And technically, that is a live round. But he's saying that's the only way. That's not true. If you have a barrel obstruction and you have a blank, which has powder and a wadding in it and a primer, then it shoots the blank out, the wadding. And that wadding can go and hit whatever's in the barrel, usually a projectile or a bullet, and it can go out. That's what happened in the Brandon Lee case. So it doesn't have to be a live round. That's not the only thing that would do that.
Court, a number of cases from New Mexico and elsewhere analyzing involuntary manslaughter in the context of a particular weapon or object. And although the postures were slightly different, the basic question was the same. Can these facts enable a reasonable jury to find involuntary manslaughter? And the courts closely analyzed the nature of the object. In one case, it was a knife. In one case, it was concrete, and what the defendant knew about the object, and found and analyzed it that way. And the same analysis has to be done here. And if the state doesn't, as they don't, contend that he had any idea there was live ammunition in that weapon, he is not guilty. He's not guilty as a matter of logic and law. And the trial is not going to be able to overcome that. Whatever other things they alleged he did, if he didn't know it had bullets in it, he cannot be guilty. He didn't know the substantial risk that it had live ammunition in it, he can't be guilty. Now, the state, Your Honor.
So basically, they're claiming ignorance. He's completely ignorant. He's a complete moron. He has no idea. I apologize for the language. He has no idea that a gun can kill people, that when you pull a trigger and pull a hammer back and pull the trigger, they're just claiming ignorance. And that's insulting to anybody who has half a brain.
Essentially has three responses to this, and I'll just go over them briefly. One, the state links its position to an unpublished decision of the Court of Appeals in the Serna case. And in that unpublished and therefore non-precedential decision, the court canvassed a number of standards that it had previously used to resolve Full-and-Font motions. And the first one it canvassed or discussed was the question of fact versus law, and it said the defendant would lose on that standard, and the question in the case was recklessness in connection with reckless driving. But as I've discussed earlier, that standard has now been rejected in published decisions in Pacheco and Platero. So that is not a good standard. That was a non-precedential decision. It went on to apply the correct standard in the alternative, which was whether the undisputed facts show that the state cannot prove its claim. And there, the facts were clearly disputed. The state disputed whether she had accelerated when she hit the pedestrian. There were disputes. Here, of course, at trial, we're going to dispute a lot of facts if it gets to a trial. But for purposes of this motion, we can take all of the state's factual assertions as undisputed, but they simply have not claimed that they can prove he had a subjective awareness of a substantial risk that the firearm had live ammunition in it.
Once again, they don't need to. All they have to prove is that he's an adult, he's been around firearms, and he knows what they're capable of. That's all they need to prove. Then there's a substantial risk. So I really, I wonder if these attorneys actually believe what they're saying. If they actually believe all this, or they're defending their client. I really wonder.
The second thing the state says, and they've said this a few times now, Your Honor, they say, well, if he had that knowledge, it would be second-degree murder. Okay, so a few things on that. One, they're just wrong about that. Second-degree murder requires a strong probability of death. If he knew there was a strong probability that there would be live ammunition in the gun, and he fired it and pulled the trigger, which of course we dispute, that would be grounds for a second-degree murder charge. But substantial risk is a lesser standard. There's a significant delta between substantial risk and strong probability. So what they need to prove for this charge is that there's that he was subjectively aware of a substantial risk that the firearm contained ammunition.
So what he's saying here is that if he knew the gun was loaded, I think he just said exactly that. He knew the gun was loaded, he pulled the trigger, pulled the hammer back, pulled the trigger, and pointed it at somebody, not necessarily in that order, and it killed somebody or caged somebody, that he would be responsible. Well, that's a given. They're saying, well, if he didn't know that. So you're saying that there was no ammo in it, and he did all those things and pointed at someone, pulled the trigger. Why would you do that? You still would never do that, even if it's empty. So it's a lame excuse. It'd be irresponsible to do that either way. So you're just saying he's not guilty, but he's a moron. That's what you're saying.
They don't even claim they can prove that. That's why it's not involuntary manslaughter. The other point on that, Your Honor, is that there's no rule that says any given factual scenario has to be able to satisfy every gradation of homicide. I mean, there are certain scenarios that are murder or nothing, based on the facts. And even if they were correct, which they're not about the second-degree murder point, that would not establish that they can show involuntary manslaughter without showing anything about his subjective awareness with respect to the risk of live ammunition. What's really, I think, telling about the second-degree murder argument is what I alluded to earlier, which is that argument shows that the state does not contend it can prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. They said it in black and white. We would have charged him with second-degree murder if that's what we thought. They can't prove it. They don't pretend to prove it. As a logical matter, they simply cannot prove the legal elements of this offense.
Once again, they don't need to. The other thing is, in this case, it's a little different. He's a producer. So if he claimed that the armorer was inexperienced and terrible, he hired her. So he's responsible for that end of it too. So he can't use that excuse.
The last point they make, Your Honor, is they refer to a bunch of other alleged actions by Mr. Baldwin. And they say that those alleged actions are enough to satisfy the elements of the offense. So there's two things to say about that. One, none of those alleged actions pose a substantial risk to the life of another person if the gun is not loaded with live ammunition. They say he knew it was a real gun.
Still responsible.
They say he pointed it and pulled the trigger. They say he didn't participate in a safety check. Again, this is not a civil suit under the ordinary negligence standard. This is not a suit for violation of the SAG guidelines. This is an involuntary manslaughter charge. And under this state's law, that requires subjective awareness that what he's doing poses a substantial risk that it could kill somebody. Pointing and pulling a trigger when you have no awareness that the gun has live ammo in it, that there's no risk that it has live ammunition in it, does not pose that risk.
See, once again, they're claiming he's ignorant. He's just dumb. That's what they're saying. He's just dumb. He's not guilty. He's just dumb. Well, I'll agree in the part he's dumb, but leave the guilty or not guilty for later.
Admittedly, this is an unusual case. Most people, when they encounter a gun in their home or somewhere, have reason to believe it might have ammunition, because ammunition typically goes with firearms. They're often preloaded with ammunition. In the typical defendant case, they're going to know that. But the reason the state won't allege that here is because it was a movie set, and this was a prop. And
there it is. There it is, waiting for it. Again, mistake, not a prop. This was a live, real firearm. Well, they said it was a cold gun, meaning he had supposedly had no ammo in it. But it was a real firearm. I'm going to say that slowly. A real firearm. Stop calling it a prop. It's not a prop. A prop is inert. I did this in my other video if you haven't seen it. It's not. It cannot function. You have the same way. It could be a real gun at one point and they fix it so it doesn't work. But this is not a prop. So once again, incorrect.
he was told by the people responsible for it that it was a cold gun. And the state told the jury, in order to secure a conviction of Ms. Gutierrez, that everyone on set believed it was empty. They told them that. They cannot come into this trial and say that he was subjectively aware. And to their credit, that's why they're not arguing that.
That doesn't make any sense. It doesn't matter. Once again, if I was to give you a gun, hand it to you and say, it's empty, and then look around everybody and everybody confirms, yeah, it's empty. Does that give you the right to turn around and point it at somebody and pull the trigger? No, that's just dumb. It's basic gun safety. You don't do that. It's a lame excuse. I don't care if everybody else says it's empty. Take responsibility for your actions.
Because they can't. They know that's not true. And they know it would contradict what they said. So those are the three arguments. I want to briefly, and I just touched on it, talk about their prior representations. As I said, I don't think the court, to resolve this motion in our favor, even needs to get into that, because I think the state has effectively conceded in their opposition brief that they cannot prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. I think that's enough. But if the court does get into those prior representations, we've given the court a number of federal cases saying that it's a due process violation for prosecutors to take inconsistent views of the facts in two different cases arising out of the same event. Of course, there's exceptions if new evidence arises. For example, if they got an acquittal in the first case and they realized, no, we were wrong about that, we're going to take the jury's views to heart, and we're going to reassess our understanding of the evidence. That's not what happened here. They used a series of representations to secure a conviction of a person. And they sort of stunningly come into this court and say they're free to walk away from those and adopt totally factually inconsistent positions. I was head of a prosecutor's office for 3 years right across the border from El Paso to Austin.
You have a good case.
And I can't imagine us ever saying in a court filing, we can take diametrically opposed positions on the facts of two criminal defendants. I would never let an AUSA do that. We've quoted them in our brief, and I won't go on extended about all the ways in which what they're saying now is inconsistent, but just a couple, Your Honor. In their opening argument, and this is at Exhibit F of our motions in this case, they told the Gutierrez jury in opening that the prospect of live ammunition on that set was incomprehensible. You can't square that with saying that he had a subjective awareness that what he was doing could kill somebody. It was incomprehensible to everybody.
Now, I don't remember that part, but if they did say that, that's a mistake, because you should never say that. You should always assume that it's a possibility. So I don't know if they did or not. I have to take his word on that one, whether they said that or not. But if they did, that's not a good thing, and they would probably bring that up again. But that's definitely not something you should say or even think. You should always assume that there's live ammunition around and that it's a possibility.
They said it's a hard and fast industry rule that live ammunition should be miles away from a film set at all times.
Of course it should.
They said the gun was checked right before it was handed to him. This was in summation. Ms. Morrissey told the jury, in order to secure a conviction of somebody, that when Halls announced cold gun, that led everyone to believe the gun contained only dummy rounds.
Once again, it's like, oh, my daddy said it's empty, so I can just pull the trigger and point it at somebody. That's lame excuse. No excuse. I don't care if he said it was empty or cold. It's your responsibility.
She said the crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job. She said, imagine I hand you a gun and I tell you it's basically empty and I walk away when in fact I put live ammunition on that. None of that is consistent with saying Mr. Baldwin had any subjective awareness that anything he did with that gun could hurt somebody else. It's totally inconsistent, and they should not be in the business of adopting factually inconsistent positions. Just a couple more, Your Honor, and then I'll get close to wrapping up my presentation because I know we have a lot to do on today. They've been inconsistent in other ways. In summation, the prosecution said it was completely foreseeable that Mr. Baldwin would manipulate the gun the way he did. But now they're saying that what he did was so out of bounds as to satisfy the standard of criminal recklessness, even though they said it was totally foreseeable on a movie set that he would do that.
Well, they probably said that if they did. I'm assuming that they did, because of his past behavior of when he had a firearm in his hand, is playing around with it, shooting it after they say cut, which we've seen him do that. And so that's, if they said that, it's probably based off of prior behavior. That's probably why they said that.
They said Ms. Gutierrez-Reed had no supervisor when it comes to weapons and gun safety on the movie set. But now their claim is that Mr. Baldwin should have micromanaged her. At least I think that's their claim from these new producer theory allegations. So the state has been inconsistent. As I said, Your Honor, I don't think you need to go there because I think they've made clear on the face of their opposition brief that they will not try to prove.
I don't think he's micromanaged. I don't think they mean that. He's saying that they expected him to micromanage. No, I think they expected him to hire someone that was qualified. And when he hired someone that was proven not to be qualified, that makes him responsible. I don't think they mean that he'd have to go over and double check everything she did, because if he hired someone that was qualified and did his job as a producer, he wouldn't have had to do that.
That he had a subjective awareness of a substantial risk that the gun was loaded. They just don't think they need to prove that. And they said, well, we would have charged him with second-degree murder if that's what we thought we had to prove, or if that's what we thought he did. Two other quick ones. A lot of their brief, Your Honor, is focused on the SAG guidelines. And it's a very, very strange sequence of arguments because they spend a number of pages saying that he was supposed to attend the check under, it's like Rule 12 of the SAG guidelines that are in the record. But I mean, if you just look at the face of this rule, it says the actor may attend the check.
Exactly.
And if you look at the testimony they solicited from their own expert, Carpenter, at Gutierrez-Reed's trial, he said this is just a dog and pony show, or it's to give a warm and fuzzy feeling to the actor. It's not necessary. And then you get about halfway through their brief, and all of a sudden they say, well, yeah, it's true. They don't actually require this. But
they don't require it, but anybody that doesn't want to hurt somebody should want to know how to use something that's in their hand, whether it be a sword or anything else. You'd think you'd want to make sure that it's safe so you don't hurt anybody.
This isn't a trial under the SAG guidelines. I mean, all that's right, but the SAG guidelines are totally irrelevant to this. I mean, whether he did the thing he can elect to do under the SAG guidelines has nothing to do with his subjective awareness that that gun in his hand could kill somebody. They also say, well, he's different than every other person on that set, every other producer, because he had the gun in his hand. He's not different in the respect that matters for this element,
that's right.
Which is, did he know that the gun in his hand could kill somebody? If any,
I do agree. In that aspect, he's 100% correct. Doesn't matter if he's a producer or not. When it comes to the gun being in his hand, it's the same as anybody else. Just because he's a producer has nothing to do with it.
Anybody on that set knew the gun in his hand could kill somebody, they would have said, oh, stop. This is crazy. And that gets, I think, to my final point before I briefly address this new producer theory, which is that each of the actions, Your Honor, that they say shows his recklessness and shows that they can satisfy the elements of the offense, pointing the gun allegedly at somebody and pulling the trigger, not attending a safety check, he knew it was a real gun, all those alleged facts that they assert in their motion. It's not only that they don't they don't satisfy the element of subjective awareness, it's that they cut exactly the other way. No one thinks Mr. Baldwin or anyone else on the set wanted to hurt anybody. The fact that they assert, some of this we can test, but the fact that they assert that he was pointing and pulling the trigger, that confirms that he had no subjective awareness that there was a live round in the gun. No one thinks he wanted to hurt anybody on the set. The facts they...
Yeah, I agree. He just proved recklessness. That if he knew there was something live in there, he wouldn't do that. But he did it. So it's reckless. He was being reckless because it's empty, I can do it, and when it's loaded, I can't. No, you can't. Basic gun safety. So the fact that he doesn't know that, or he's claiming he doesn't know that, it's reckless. So there's recklessness right there. It's a lack of common sense, I guess you'd say.
They cite as satisfying their burden under that element show exactly the opposite. They show that they absolutely cannot show that he had a subjective awareness that that gun could kill somebody. No one thinks he would have pointed and pulled the trigger if he knew that, if he knew there was any risk of that.
Well, you would think that's a given. Otherwise, he'd be a murderer. Okay, we don't believe he did it on purpose. So that's just semantics.
So the facts they cite show exactly the opposite of what they cite them for. Last point, Your Honor, they've raised this new producer theory. It's not totally clear to me exactly what they're saying, but I think they're saying one of two things. The first one is they might be alleging some sort of supervisory liability, even if Mr. Baldwin had no awareness. He was negligent in supervising Ms. Gutierrez-Reed. Now, there's a ton of factual problems with that. That wasn't his responsibility, but those are not relevant for this motion. What's relevant here is that there is no supervisory liability criminal statute. You can't establish the mens rea, the subjective awareness based on a supervisory theory. That can't possibly work. The other thing they might be saying is that he should have known the gun was loaded or something. They haven't articulated this, but it seems to be what they're saying. But again, it's not that standard. He must be subjectively aware. He must
not that he should have known. He should have assumed it was loaded. Proper gun safety.
Have subjective knowledge of the risk, and that's clear as day in Henley. That decision's controlling, and for that reason, they can't meet their burden on this. So we reserve time for rebuttal, of course, but we respectfully ask this court to dismiss these charges because Mr. Baldwin is innocent as a matter of law. Thank you.
All right, before the state responds, I have a couple of questions over some of what you presented. So you said that that you can take the undisputed facts under Fool and Font, and I'm interpreting that to mean that you can ignore the disputed facts. And I don't read Fool and Font to be that.
No, Your Honor, the way I would describe it is you give the state everything they're alleging. So some of those facts are undisputed and some of those facts may be disputed. So for example, there's a dispute about whether he pulled the trigger. Give the state that, obviously not at the trial, but for the purposes of this motion, give the state those disputed facts. Assume they can prove. The way Pacheco describes it is there a reasonable probability that they can obtain evidence to prove those elements? So if they, as long as it's not totally ridiculous, if they say this is a disputed fact, we think he pulled the trigger, give them that for the purpose of the Fool and Font motion. Can they prove the elements even with that? And our submission is that no, they cannot, because they don't even attempt to allege that he had a subjective awareness of a substantial risk that that firearm was loaded with live ammunition. So give them everything else they say. Give them the disputed facts. They don't dispute that. It's clear on the face, pages 14 and 15 of their op. They do not dispute that.
Okay.
What about the disputed facts? You talked about that they've raised additional facts. What about all the case law that says if you have disputed facts, it's for the fact finder? It is not for the court.
Exactly.
Your Honor, that's true only where the disputed facts, if resolved by the fact finder in favor of the state, could satisfy the elements of the offense. Our submission today is that assume the fact finder resolves every disputed fact in the state's favor. They do not contend he was subjectively aware that the gun in his hand could kill somebody, because they don't contend that he was subjectively aware that there was any substantial risk that it had live ammunition in it.
Keep saying the same
So
thing over
give
and
them
over
everything
again.
else they say. Give them they pulled the trigger. Give them he didn't attend the safety check. Give them all that for the purpose of this motion. Assume the jury resolves all of that in their favor. They still can't meet the elements of the offense. And that is the essence of a full and fine. I would call it a Pacheco motion, because Pacheco really refined the standard. But that's the essence of the motion presented to the court right now.
All right, well, let me read from Henley, because you read a certain portion of Henley, but there's more to Henley, and it says, criminal negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness, in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property.
Exactly. So in other words, pointing a gun at somebody and pulling a trigger.
UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions.
Yes.
14231. To be convicted of involuntary manslaughter, a defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else.
See, like I said, because he's a producer, there's a whole other element in this, because what she's saying here is based on the fact that he's a producer as well.
The SAG guidelines that they don't completely rely on, and I think you said that they rely. If you said completely, they rely on them in part, and they're saying that as an actor,
let's be honest, the SAG guidelines are there to protect SAG and the Actors Guild. They don't care whether they do it or not.
Despite,
in my opinion,
despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone.
Exactly.
And there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to.
Exactly.
So I'm curious as to how you have limited it to he has no knowledge, because he got to rely on his armorer, he got to rely on David Halls, and you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements.
Yeah, how does he do that? Because he's paid to do that. I don't think he really believes it.
And that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, Murrieta, which you rely on very heavily, it says,
Now you have all these facts that are disputed. He's saying they're disputed, and they shouldn't be in the case. They're disputed. Well, that's why you have a trial. You have disputed facts, give it to the jury, and the jury decides. But he's trying to get all that out. That's just basically what she's saying. He said, doesn't make any sense. It's up to the jury.
State versus Murrieta.
That's why you have a trial.
Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence, as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Murrieta in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide.
Exactly.
So to me,
Boom.
and you did acknowledge
Just drop
that
the bomb.
they added, that they
All right,
have
sorry.
additional facts.
Just drop
Remember,
the
the
mic.
case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the core of whether the jury believes your facts about the armor and David Hall's and that he had every reason to be able to rely on them, and the state's alleged facts that he was a producer, he knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false. I'm just wondering how you're reconciling these things.
Let me take a stab at that, Your Honor, and let me give you the short answer and then the slightly longer answer from both case law and the record.
To do that.
The short answer is add up all the facts that they say are disputed. Assume they win those. It still doesn't meet the legal elements of the offense. So you could imagine even easier cases than this,
In your opinion.
where something ridiculous. You know, there's a murder charge, but the person's not dead. And no matter what else is disputed, they're obviously not going to be able to prove a murder charge if the person's not dead. It doesn't matter if there's disputed facts.
That's weak.
In this case, and let me pick up on Henley. Your Honor quoted the carryover paragraph from pages 107 to 108 in the Pacific Reporter. The very next sentence, the first full paragraph on page 108, gives the standard that's at the heart of our motion. It says, our case law has long interpreted the requirement of subjective knowledge into the the requirement of subjective knowledge into the showing of criminal negligence required by our involuntary manslaughter statute. Later in the same paragraph, it says criminal negligence in the context of involuntary manslaughter requires subjective knowledge by the defendant of the danger or risk. So the parts that Your Honor quoted are the model instruction. You know, we don't take issue with any of that. They may also have to prove objective knowledge, which is the should have known standard. But the subjective component, whether it's an independent component or part of what willful disregard and conscious disregard means in this context, it's clearly a requirement of the statute. I don't hear the state to disagree with this point. I mean, they can read the case just as well as anybody, and I don't hear them to disagree that subjective knowledge is a requirement under the statute. Now, Your Honor asked about these different factual allegations, whether the Hall's check was insufficient.
He just keeps going over the same stuff over and over. And I give him credit. He's doing his job, but he's just rambling here.
And so forth. Our submission is that even if all those were true, just as a logical matter, if he is not subjectively aware of a substantial risk that there's live ammunition in that gun, and they don't allege he is, he cannot satisfy that element of the offense. Because
I don't know. I think you learn that once you're little. If you just keep repeating the same thing over and over again until you hope that they believe you, that's not a good thing. Just keep saying the same thing over and over again, like it's got to change.
The only way that gun can kill somebody is if there's live ammunition in it. They can allege whatever else they want about he violated the SAG guidelines or he did this and that. But if they can't allege that he has plausibly, that there was he was subjectively aware of a substantial risk that the firearm contained live ammunition, they simply cannot meet the elements of the offense. I know Your Honor asked about Moreta. That case in the quote Your Honor presented says generally intent is a question for the jury. And we have no dispute with that. I mean, in most cases, recklessness, knowledge, intent, that's going to go to the jury, unquestionably.
And so
but where the state cannot allege, does not even purport to be able to prove an essential link, namely that the defendant understood that his actions had a substantial risk of hurting somebody else, it should not go to the jury. The Rule 601, the Rule 5601D standard is there because the judge is a critical gateway on allowing defendants to be prosecuted for things that are not crimes. What they have alleged here is not a crime. You cannot be guilty of involuntary manslaughter if you had no awareness of a substantial risk that what you were doing could harm people. And in the case of a gun.
So once again, he can't be guilty because he's just dumb. That's what they're saying. He's dumb, so he's not guilty.
In this very unusual case of a prop on a movie set, where
once again, stop saying that. It's not a prop. So they're putting out that false information again, and that's dangerous.
Everyone, according to the state, believed it was empty. You cannot satisfy the mens rea for involuntary manslaughter.
Thank you. State's response.
Let's get to the state finally.
Your Honor, as a preliminary matter, I want to ask the court. I know that the defendant filed a request for supplemental briefing, kind of along with a supplemental brief yesterday, and we provided our response to that at around midnight. Is the court permitting the additional briefing? I hear Mr. Bash arguing the law and the facts that are in the additional briefing. So I just want to know what I'm responsible for.
Hello.
No, I did not see that, and it's late. So
Yeah, move on.
Okay.
Your Honor, can I just respond? I mean, other than the brief mention of the producer theory, I don't think anything I argued had anything to do with the supplemental briefing.
So he's right, but that's important because he said the state's new theory of him being a producer.
Right.
Judge, you even know about it, so it's not new.
It's nothing new.
Because I believe it came out during the Gutierrez trial, and as we indicated in our response,
here's what we're doing. Here's what we're doing today. What I received and what I set for hearing. So a supplemental briefing that arrived yesterday is
Right.
not on the table in my decision.
Judge taking
understood.
control.
Thank you.
Take
I'll go
control.
ahead and proceed with my response. The circumstantial evidence that the state intends to present that goes squarely to this issue is Mr. Baldwin knew he had a real gun in his hand.
Check.
Mr. Baldwin specifically asked for the biggest gun that was available. Mr. Baldwin knew and understood that dummy rounds look identical to live ammunition.
Yep.
That's the foundation.
See, one of them, in my opinion, one of the mistakes that Alec made is through his arrogance. Like I said, in my opinion, is when he was questioned by the police, is he was going on and on about how much knowledge he had about firearms and blanks and dummy rounds and all the stuff and prop guns. He was going on and on about all his experience and try to impress them. And so now he can't claim ignorance, which he know he's going to try to do.
So before Mr. Baldwin has ever even encountered training by Ms. Gutierrez, that's where we are. He then arrives to his training with Ms. Gutierrez and doesn't pay attention. Not only did Ms. Gutierrez indicate that he didn't pay attention, Ms. Zachary actually took a video of him not paying attention.
That's not good.
And it's one of the exhibits that will be used in the destruction of evidence motion later today.
Now, see, I watched the first trial. Never heard that before. So that's news to me. So that's going to be really interesting.
So
Sorry.
he decided not to pay attention during his training.
Haven't eaten.
Then, and look, anybody who looks at Ms. Gutierrez understands that Ms. Gutierrez hasn't been alive long enough to legally own firearms. So there has to be some question about, is this person really qualified to have this job? Any reasonable human being would have that concern, and many of the crew members actually mentioned that to the producers. How can this lady be our armorer? She's like in her early 20s.
You want to know how? Because of her daddy. That's all. She knew somebody. That's how it works. And that's very dangerous when it comes to firearms, especially.
So Mr. Baldwin certainly understood that. He had a bad armorer. She wasn't doing proper safety checks. His experience in the film industry is absolutely circumstantial evidence that he knew that when she was doing these safety checks that she wasn't following the rules. Absolutely, the court is right. He also understood that Mr. Halls was not checking the gun with Ms. Gutierrez every single time. We know that he knew that because that's what he said to law enforcement on October 21st.
Well, if they can prove that he knew that she wasn't doing safety checks and he was okay with that, if they can prove that, that's bad.
So we get to this point. Now let's take into consideration that there are two other actors on set that Mr. Baldwin can see dry firing their guns into the ground 10 times after the gun is handed to them by Ms. Gutierrez to ensure that every single round is inert. Are those actors on my witness list? No. Do I have plenty of other witnesses who are going to come in and say, we saw those people dry fire their guns into the ground every time she handed it to them? Absolutely.
Now, like I said, I watched the first trial. I'm sure you guys that are watching this, you did too. I don't remember that ever being said. So if that's true, that's news too. This is going to be a real interesting trial for sure.
Plenty of witnesses are going to testify to that, and Ms. Gutierrez herself should be able to testify to that based upon the court's ruling, because that certainly wouldn't be anything that she could assert her fifth to. So that's where we find ourselves at this point in time. Now, what Mr. Bash is telling the court, which is absolutely false, what he's telling the court is, unless this gun has a live round in it, it is completely harmless.
Right.
And he didn't realize that there was a live round in it. Patently false.
I agree with her.
Mr. Baldwin himself, as I recall, had a conversation with law enforcement, and I may be wrong. I've read a lot of transcripts. He indicated an awareness that if he is handed a gun that has a blank round in it, but also has a barrel obstruction,
here we go,
that is fatal. That can kill someone and has historically killed people. I believe that is the circumstance of the death of Brandon Lee.
Absolutely 100% correct. That's what I was saying earlier. And like I said, when he was doing his interrogation, he was bragging about how much knowledge he has that impressed the two female officers, I guess. Maybe that's why. I don't know. Maybe that's just because who he is, whether male or female. I'm just assuming that. But yeah, he did. He was telling everybody how much knowledge he has. So now you can't claim ignorance. You can't have it both ways. So good luck with that one.
That almost everybody who works in the film industry is familiar with. So Mr. Baldwin didn't necessarily have to know there's live ammunition in this gun. He had to understand that the gun is real. Real guns are dangerous. Dummies look exactly like live ammo. Even if there's not a live round on set and she put a blank in instead of a dummy and the gun had a barrel obstruction, Helena Hutchins is dead.
That's it. That's all of it in a nutshell. This lady's good. She nailed it, in my opinion.
She's dead. And she's dead because he didn't participate in the safety check. And listen, we agree, and we have always agreed that under the SAG guidelines, which do not dictate New Mexico law,
correct,
the SAG guidelines indicate that that is optional. He chose not to participate, and I'm sure that's a decision that he's grown to regret.
Yep, that's exactly what I said in the video I did on it. He chose not to. He didn't have to. It wasn't required, but he chose not to.
So he chose not to participate in that safety check. Then he decided to point a gun at a human being, cock it when he wasn't told to cock it. We have plenty of video of him cocking guns when he wasn't supposed to, when he hadn't been told to, when the scene didn't call for it. And then, of course, he pulled the trigger, killed a woman, and seriously injured someone else.
See, that's what I was saying earlier when they were claiming his actions and the way he behaves with firearms is because they have evidence that he's done it in the past. That's why they're claiming that.
So that's the landscape, and the court is absolutely 100% correct. The defendant has spent pages and pages and pages and pages arguing, we don't agree. We don't agree to the facts.
Right. That's why you have a jury.
There are really no stipulated facts. The state isn't stipulating that in order for that gun to have killed someone, it had to have live ammunition in it.
Right.
Everybody knows that's not true.
Exactly. Unless you're being paid to say something otherwise.
Now, let me clear up a couple of other issues.
I wouldn't want her coming after me, I tell you that. This lady's good.
The reason that these safety rules exist, the entire reason that the SAG Safety Bulletin number 1 exists, is because of the risk that live ammunition could find its way on set. If there was absolutely no chance that live ammunition could ever find its way onto a movie set.
Now, let's make this real clear. I'm not saying she's good for being a woman. She's a great attorney, regardless of gender. So let's not start doing that. She is a great attorney, and I wouldn't want her after me. So it doesn't matter whether she's male or female. She's good at her job.
Why have these rules at all? You've got 2 actors standing right next to Mr. Baldwin who certainly understand that there's a significant risk of live ammunition, or they wouldn't be firing their guns into the ground right in front of him. Now,
yeah, I've never heard that before, so that's interesting.
Our expert, Brian Carpenter, will testify and testified before the grand jury, and I think he even testified during the Gutierrez trial, that as an armor, he himself has found live ammunition on a movie set.
It's always a possibility.
So,
you have to assume that. You should always assume that. Just to be extra safe.
What Mr. Bash alleges with regard to the distinction between involuntary manslaughter and second-degree murder really, I don't think gets him where he needs to be. If I am an actor and I have reason to believe that I understand that there is a substantial risk that there is live ammunition on a movie set, and I take that gun and I point it at a person and I cock it and I pull the trigger, that is second-degree murder all day long. We can argue about that all morning,
Could
but
not agree
that's
more.
not going to change.
It's just basic facts. It's
I think that where the parties disagree here is when Mr. Bash was talking about the link, the link between the subjective knowledge and the offense, the link between the conduct, the subjective knowledge and the offense. We disagree on what the link is. Not only do we disagree on the vast majority of the facts, we disagree on that link. This motion by Mr. Baldwin absolutely cannot be granted by this court. There is a plethora of case law that says you can't do it. And what is happening here, which is what frequently happens in this case, is the defense attorneys are coming forward to the court and they're saying they're making statements that are not at all based on the evidence or the future witness testimony.
Shocker.
One of those statements that was given today, of course, is Mr. Bash's statement, this gun can only kill someone if it's got live ammunition in it. Absolutely false.
I agree. That's what I said. Nailed it. Right on point. Nothing else to say. She said it for me.
And Mr. Baldwin knew that was false. So we need to simply rely on New Mexico law. We have an extraordinary amount of circumstantial evidence that goes directly to this point. Some of that evidence you may see this afternoon because it's relevant to another motion. The court, if the court in Cerna, which is the unpublished case that the defense, that the state cited, that the defense was certainly aware of. They were aware of Cerna. They were aware of Gomez. They didn't cite him because they were hoping, I guess, we wouldn't find him. So when you look at Cerna, there's a video. There is a video of a person driving and a pedestrian stepping out in front of them.
Yeah.
And the only dispute between the parties is exactly what Mr. Bash is bringing to the court's attention today, which is, with substantial risk, how can you get there when you look at this video and all this lady, she wasn't speeding. All she did was just kind of make this turn and hits this pedestrian. And for heaven's sakes, it was an accident. And in that circumstance, the court said, no, there are disputed facts. There are disputed facts here. And we are asking the court to follow well-established New Mexico law and deny the defendant's motion. Thank you.
Yeah. So there's disputed facts. That's why you have a trial to settle that. That's what a jury's for. Or a judge if he chooses just to have a judge, which
Response,
I know he's not
Mr.
doing
Bash.
that.
Thank you, Your Honor. Much of what the government just said is incorrect, but as an umbrella point, much of what the government just said is waived. It appears nowhere in their opposition brief, the point about blanks, the point about what two other actors were doing on the set. There's been a lot of sandbagging in this case. It's not proper for when we make an important dispositive motion, the state not to present those arguments in their written submission and then to debut them for the first time at argument. The arguments are wrong, and I'm happy to address them, and I will in a second.
I'm sure you will.
A lot of the points you just heard are not found in the brief of the state, and that you can't raise something at an oral motion for the first time without previewing it. So let me take each of those points in turn.
Quickly, please.
Ms. Morrissey went over a lot of their allegations, and some of them just have obviously no bearing on the issue before the court. Whether he selected the biggest gun, whether Ms. Gutierrez looked too young for the job, that has no bearing on whether he had a subjective knowledge of a substantial risk that the gun in his hand could kill somebody.
No, I agree with him when it comes to the biggest gun. That's just that doesn't matter. So if he asked for the biggest gun and you don't point it at anybody, then it doesn't matter. But the fact that she's young is kind of relevant because he knows that she's inexperienced just based on her youth alone. And yet he hired her. So he has to have knowledge that she's not the most experienced armorer that he could have got.
They've given a lot of facts. Let's give them all those facts. Let's give them all the jump balls. Let's say that they're right about everything they say. That does not establish the element of the offense. And we've been over some of those in the opening presentation, that he had the gun in his hand, that he knew dummies look like live rounds. Yeah. The fact remains that they told a jury to secure a conviction that everyone on that set did not believe there were live rounds in that gun, and that it was inconceivable that there could be live ammunition on that set. And
it doesn't matter. Once again, it doesn't matter. So if everybody says there's no ammo there, then it's okay. You can point it at anybody. That's so lame.
One includes Mr. Baldwin. Now, they've raised two arguments. I guess they've realized that they have a big problem, because if they can't show that he had a subjective awareness that firearm was dangerous in his hand, they can't prove their case. And so they've raised two totally new arguments, which were...
I think, real quick, I think the biggest problem we have in this country in general is people don't take responsibility for their actions. There's too many people that pass the buck or want to do dumb things or reckless things or make mistakes, even if it was on purpose, and then don't own up to it. You make a mistake, you own up to it. Take responsibility for your actions.
Not in the opposition brief. Someone can correct me if I'm wrong. I'm doing it from memory, but I don't remember seeing these arguments in the opposition brief. First, they say that Mr. Baldwin saw two actors dry firing their guns, but they're not going to call those actors, but they saw it. I don't see that anywhere in the brief. Second, they say that it's not true that you need a live round. In certain circumstances, a blank could kill someone because there could be an obstruction in the barrel and it could go off.
It could.
But no one contends, Your Honor, that he thought there was a substantial risk that gun contained blanks, because as everybody knows, and I'm sure the court is very familiar after sitting through the Gutierrez trial, they look completely different than dummy rounds. Dummy rounds are the ones that look like live rounds. Blanks look totally different. And I'm not aware the state has ever contended that Mr. Baldwin was aware of a substantial risk that Mr. Halls or Ms. Gutierrez loaded blanks into that gun, which looked totally different. It's not even remotely realistic that was a risk after two professionals loaded the gun.
So it makes more sense to, there's no blank in there, because if there's a blank in there, I wouldn't point it at anybody because there might be a barrel obstruction. But if you put a dummy round in there that I didn't check, that looks like a live round, unless you check, That makes more sense to point it at somebody. That is dumb. That is really dumb.
Excellently loaded it with blanks. So that is an argument that the state just made up an argument. They didn't even include it in their written briefs, and it's completely preposterous in light of the reality of what blanks look like. It's an argument to try to get past a dispositive motion that doesn't actually have any weight. I would just add that I think they would have a huge problem with the foreseeability element if their theory was that he foresaw that there could have been obstruction that could have injured somebody, but actually what happened was totally different, and so he's guilty. I don't think they could satisfy foreseeability, but at any rate, the argument's waived, and it's factually ludicrous given that these things look different. There's no way he could have had a subjective awareness that there was a risk they were putting blanks into that gun. Ms. Morrissey referred to the SAG guidelines, and they say we have these prophylactic rules under the SAG guidelines because, you know, there's some chance of live ammunition. And so you can never say there's no chance.
That's right.
Again, let's assume she's right about all that. I don't want to get into whether she's right about the purpose of the SAG guidelines.
Because she's right.
The standard is not no chance. The standard is a substantial risk. You heard it again. They can't argue substantial risk. They can't argue subjective awareness of a substantial risk. They would have charged second-degree murder if they thought they could argue it. So they moved the goalpost. And they've moved the goalpost to, well, we can't say there's no chance. I mean, there's always some 0.0001% chance of anything happening. But that's way far away from the element of this offense, which is substantial risk. She doesn't argue that properly because she can't argue that. She changed the goalpost. I heard her say something about the second-degree murder. Well, you're just wrong about that.
Now she changed them.
Mountains of case law
So
say
you
you're wrong.
changed the
There was no
goalpost?
case law cited. There was
you
no
moved them?
logical reason
Not
given.
both.
Second-degree murder in this state requires a substantial probability. If the state could allege that Mr. Baldwin thought there was a substantial probability that there was live ammunition in the gun and it could satisfy all the other elements, that would be a different story. But what we're saying is they haven't even alleged a substantial risk. There's a big
They don't need to prove it for the last time. We're going to say this one time real slow so he can get it. They do not need to prove that. He had it in his hand. He's responsible. That simple.
delta between strong possibility and substantial risk. And if they can't even allege that, then it's not involuntary manslaughter. It's an accident for which he's not criminally liable. I heard Ms. Morrissey say that there's a plethora of case law that says you can't do a full and font motion in these circumstances. There's not, they don't cite it. They just keep saying there's a plethora of case law. Moreta stands for the exact opposite
We're getting to the
proposition.
end here.
It says generally they're not going to be successful. We have no truck with that. Of course, generally the prosecutors are going to be able to get intent to the jury. But this is an extraordinary case where they're charging somebody with an accident based on a movie prop when they told another jury that everyone thought it didn't have live bullets in it.
Not a prop.
This is an unusual case. And Moreta would have had one sentence of analysis if the rule was you can't succeed on a full and font motion on a question of intent. It didn't. It went very carefully through the allegations, and there was an attached affidavit, and it went very carefully through all that and said, okay, the state has enough here to prove the case. So they're wrong about that. And
See, that's why it's manslaughter. Not going for murder. They didn't say he purposely did it. He said he did it recklessly. He should have known better. That's why it's manslaughter. He should have known better.
finally, I mean, Ms. Morrissey says, well, I know why the defense didn't cite Serna because they're scared of it. I mean, it's an unpublished non-precedential decision that alternatively applies a test that the Court of Appeals rejected in 2 published decisions. Okay, so it's not controlling. It does alternatively apply the correct standard, which is what the undisputed of facts allow the state to prove. And I mean, it was just a case with completely different facts. She said it's exactly the same thing. It's not. One of the facts disputed in that case, which was a vehicular case, or a reckless driving case, was whether the defendant had accelerated at an unreasonable rate right before she hit the pedestrian. That was an actual factual dispute that goes to recklessness, and that could be dispositive. In this case, the state does not claim that he had a subjective awareness of a substantial risk that the firearm contained live ammunition. It's not disputed.
Keep saying it
For everything that Ms. Morrissey just said,
over and
they're
over
not
again.
disputing that. She was candid.
Maybe
She
they'll
did not
believe it.
stand here and say they can dispute that. There's a reason she didn't. They know they can't prove that. They know it would be inconsistent with what they told a jury to get a conviction of somebody else. They can't prove that. If they can't prove that, they can't establish the elements of the offense. And with that, I'll sit down, Your Honor.
All right, here we go. Here's the rolling.
Court makes the following ruling. The court denies the full and font motion of the defense. The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying that there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known. With respect to the inconsistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit U.S. versus Negro is on point, where it's got to go to the core, prevail on due process claim. It's got to go to the core, and that it's got to be which is so inherently contradictory. And I think that I think part of what the state's relying on is what Ms. Gutierrez didn't do.
Yep.
Okay. And the court will prepare that order as well.
All right, guys, that's going to do it for the video. I know it was long, but hopefully you got something out of it, because my goal with this is to try to not just give you my opinion, but give you the knowledge that I have when it comes to firearms. And hopefully you'll learn something new or something you didn't know. And I didn't irritate you too much. So if you stuck to the whole video, I really appreciate it. So if you got something out of it, like I said, I appreciate it if you subscribe if you haven't already. And that's going to do it. So until next time, like I always say, stay safe, stay curious, and remember to always mind your surroundings. Bye.